We will hear argument first this morning in Case 25-6, Keithley versus Buddy Ayers Construction. Mr. Garr.
Thank you, Mr. Chief Justice, and may it please the Court. Judicial estoppel prevents a party from deliberately adopting inconsistent positions to gain an unfair advantage in litigation. Because the doctrine targets intentional inconsistencies, courts have resisted its application when a party's prior position is based on inadvertence or mistake. The narrow but important question in this case is how to determine when a party's position was inadvertent or intentional in the specific context where a debtor fails to update a form to reflect a new cause of action outside of bankruptcy. If the failure to update the form was simply a mistake, then there's no intentional inconsistency and no basis to invoke judicial estoppel. The Fifth Circuit applies what amounts to a conclusive presumption that a debtor's failure to disclose a cause of action and through updating a form is intentional as long as the debtor knew of the facts underlying the claim and had a potential financial motive to shield the asset, something which exists almost by definition in the case of any bankruptcy. That rule flouts the flexibility that equity ordinarily demands. It grants a windfall to alleged wrongdoers who have no connection to the bankruptcy, and it unfairly penalizes honest debtors by denying them redress for real wrongs. This Court should reject the Fifth Circuit's rule and hold instead that courts must undertake a holistic analysis of all facts bearing on a debtor's intent before concluding that a debtor's failure to update a form represents an intentional position that no cause of action exists. Erasing a debtor's claim seeking redress for tortious or other illegal conduct, like petitioner's personal injury action here, imposes an enormous cost on individuals already facing hard times. There's no basis for taking that extreme step based on a conclusive presumption that may be entirely unfounded. I welcome the Court's questions.
Mr. Garr, what type of evidence should be used in your holistic approach?
So we would look to all surrounding circumstances, Your Honor, objective and subjective. It would include the debtor's own testimony, typically, but that would just be one factor. You'd look at the sophistication of the debtor, when and the manner in which the debtor updated the form, whether the debtor told his attorney of the cause of action, whether creditors objected when a form was amended, the impact on creditors or others in the bankruptcy court's own findings. These are objective factors that courts have looked to and can be applied in determining a debtor's actual intent.
One factor you haven't mentioned is, of course, the impact on the judiciary, the judicial reputation, sort of phrases that have traditionally been used here. All that you've been talking about is between the two parties to the bankruptcy and the accident. Where does that factor in? I thought that was the primary basis for the whole doctrine of judicial estoppel. You don't want to put the courts in the position of acting on the basis of a counterfactual. That's not true.
Absolutely, Your Honor. That's the backbone of judicial estoppel. This Court and others have talked about playing fast and loose in with the courts and protecting the integrity of the courts. And what this Court recognized in New Hampshire is that where the integrity is impacted is where parties intentionally advance inconsistent positions in order to gain advantage in litigation. And to put the courts in the position of potentially adopting those inconsistent positions is what undermines the integrity of the courts.
I thought it was more that they proceeded on the basis of a particular, not assumption, but what was shown, and you don't want to put them in a position of having two different versions of reality and then proceeding on the basis of one or the other.
So I think what the courts have described it as is the cold manipulation of the process, Your Honor, and that happens when an individual intentionally takes one position, secures an advantage by the adoption of that position, turns around in a different proceeding, adopts a different position, and tries to get a different advantage. If the individual didn't intentionally adopt that first position and corrects it, as happens in the scenario here where a debtor is simply unaware And as the amici former bankruptcy judges indicate, bankruptcy forms are very confusing. Even with the aid of counsel, many debtors simply just don't realize that a cause of action is an asset and forms have to be updated. In that situation, the debtor has made simply a mistake in failing to update the court as to the existence of the cause of action. And there, the debtor is not actually taking the position that there is no cause of action before the bankruptcy court. He simply failed because of his mistake to update a form. So there is no intentional inconsistency. There's no playing fast and loose with the courts. There's no cold manipulation of the judicial process. And there's no threat to the integrity of the court. And conversely, I mean, judicial estoppel is an extreme measure. And it's appropriate where there is a threat to the integrity of the court, but it involves wiping out a cause of action. And here you have a situation in which courts, without even engaging in a holistic determination as to the debtor's actual intent, whether the debtor simply made a mistake in failing to update a form, are wiping out a cause of action like Mr. Keithley's personal injury action here. The respondent's own driver admitted that his brakes failed. And that his truck hit Mr. Keithley's, and that action has been wiped out based on a conclusive presumption that the Fifth Circuit applies, that simply because a debtor has a potential financial motive to mislead, a debtor's failure to update the bankruptcy court as to the existence of a cause of action is an intentional representation.
Mr. Garr, can I interrupt you and ask you a question? This is an eerie question. This was a diversity suit, so why does the federal law, everyone's assumed that the Fifth Circuit's law of judicial estoppel applies. Is the Mississippi law different? And if not, why doesn't the Mississippi law control in the diversity suit under Erie?
So I think, as I understand this court's decision in New Hampshire versus Maine, I mean, the judicial estoppel doctrine as embraced by this court is, a federal law, common law type rule inherent in the court's own authority to protect its proceedings, and so I think that would be a federal baseline. I mean, state courts have applied it as well. I think here no one has pointed to any difference in the proceedings.
I gather that it's a matter of some dispute in other circuits, that courts have struggled with that question, and I don't want to resolve it here. I don't think we have to resolve it here, but I certainly wouldn't want anything we said here to resolve that question. I mean, I can see arguments on either side. I think what you're saying might be kind of a Byrd versus Blue Ridge. The overriding federal interest overcomes whatever we might say about the outcome determinative prong of Erie. It just seems to me like that might be something, I just wanted to know your reaction about it because it might be something to avoid.
So I think the court, can and absolutely should reserve that question for a later day. Your Honor, I'm not aware of any inconsistency in state or federal courts in terms of recognizing that judicial estoppel doctrine wouldn't apply in the case of an honest mistake. I think courts across the board have focused on what they call the cold manipulation of the courts and the judicial process.
Okay, just one last question then. Speaking of just questions to avoid, do you see your argument as really kind of confined to how judicial estoppel plays out in the bankruptcy context in particular? Or
Yes.
do you see it? Okay, why?
Yes. Well, that's the situation, and this has arisen. I mean, it's unique in the important respect is typically when a judicial estoppel has applied in another context like New Hampshire versus Maine, you have a party that's affirmatively adopted two different positions. And there's no question what the party thinks his position is. Here, in the bankruptcy context where a debtor has failed to update a form, the position is implied by the failure to update the form, but the debtor hasn't actually affirmatively said, I have no cause of action. Where judicial estoppel is invoked, there's a presumption in the Fifth Circuit that the debtor, in fact, made that representation. So that the context is different in important ways. In New Hampshire, this court, in outlining general principles that typically apply, recognize that additional considerations would be appropriate in specific factual contexts. So I think the context here is important. Also, in this context, you have individuals who, very often are not particularly sophisticated. You have an environment, bankruptcy, where forms are complex. Again, the amici former bankruptcy judges here and themselves have talked about the complexity of the forms. They're confusing, even with the aid of counsel. And so I think that's the situation, in particular, this context, where one would be wary about there was any position at all or whether a debtor simply made an honest mistake in failing to update a form.
Mr. Garr, I've been having trouble trying to fit in our New Hampshire principle to the bankruptcy context, where the bankruptcy it has not terminated, meaning in a situation like this one where the bankruptcy is still ongoing, because logically and otherwise, it should be the bankruptcy court that decides whether to impose a penalty, because doing away with the personal injury suit deprives the creditors of a potential source of income for the bankruptcy. In an ongoing bankruptcy, that's a draconian effect on the creditors that the second court would be imposing. So I'm not sure how equitable estoppel really can play out on the principles set forth in New Hampshire. New Hampshire said that the first court had to be persuaded to accept that party's earlier position. But here, with the amendment, there was no permanent acceptance of a position by the bankruptcy court. It also, how New Hampshire said, a court has to consider whether the party seeking to assert an inconsistent position derived an unfair advantage or imposed an unfair detriment on the opposing party. But the opposing party here, there's no unfair detriment to the man who hit your client with a truck because he wasn't involved in the bankruptcy. And the unfair advantage was wiped away once the disclosure was made in the bankruptcy court. So I've been perplexed when I started with this, how we deal with that context in this special situation where the bankruptcy has not terminated. There's been no final determination that the bankruptcy court was misled in a way that caused detriment to the bankruptcy process, to its creditors, or to anyone.
So I'm not going to quarrel with anything that would lead to the conclusion that judicial estoppel doesn't wipe out my client's claim, Your Honor. What I would say, though, is
maybe this is a question for the other side, but I've been having a hard time understanding how this theory works in a situation in which it's different parties and not the same parties being misled.
So in New Hampshire, the court did reference a possibility that either the first court or the second would be misled, and I think that's probably the theory that courts have applied here. I think what Your Honor's question underscores, though, is that here the bankruptcy court, you have a proceeding ongoing, the bankruptcy court is well equipped to take any action it determines is appropriate to protect other creditors. Other creditors can stand up as well to sanction conduct that it believes is misleading or deceitful. And so there's not the need for a sort of overarching judicial estoppel check here. And that makes it all the more egregious, frankly, for the Fifth Circuit to simply disregard all that and adopt this conclusive presumption that a debtor is acting with an intent to adopt a position that no cause of action exists and to mislead the courts.
Mr. Garr, can I ask you, because I'm trying to ascertain your position with respect to what suffices for establishing inadvertence or mistake. You've talked about intentional omissions as they relate to misleading the courts, but you can imagine a world, I think, in which the debtor might have an intent to omit, perhaps to mislead someone else. So, a debtor who's, say, contemplating a divorce, they leave off the claim because they want to have less exposure in the case if they decide to go through with the divorce. So it's intentional, but not with the point of misleading the court. How would you say that should be taken into account, or should it, in regard to figuring out whether there was inadvertence or mistake?
So, Justice Jackson, I think, first of all, that the key is that the court has to determine that the debtor has made adopted an intentional position that no cause of action exists. I think that the heartland in which judicial estoppel is invoked, the understanding is that the debtor is trying to mislead the court to gain advantage. And your hypothetical, I don't think that would invoke the heartland of judicial estoppel. Nevertheless, I think judicial estoppel being an equitable doctrine, considering additional factors, that could be part of the mix.
All taken into account in terms of your holistic view. And so your argument here is that the Fifth Circuit's test is too rigid because it doesn't allow for full consideration of intent or other factors that could bear on inadvertence or mistake.
That's exactly right. I mean, our position is that the inquiry into the debtor's intent here as to whether they intentionally adopted a position that no cause of action exists should be undertaken.
But does it matter that their motive is different? I mean, so in my hypothetical, they did intend. They intended to omit. So it's not inadvertent or mistaken. What then? I mean,
so I think that, I'm sorry, Your Honor.
No,
I think that's a good example where, really the bankruptcy judge is in charge of his or her proceedings and can take appropriate action. In that situation, no doubt the judge would think it's improper and perhaps warrant sanction that the debtor is attempting to hide his assets from his spouse or others, and so sanctions might be warranted. I don't think that that's the typical fact pattern in which judicial estoppel is warranted, but I think what distinguishes this case is there's just no determination that the debtor here actually intended to hide anything from the court.
Mr. Garr, on that, just to follow up on it, why is intent to mislead the court essential? I struggle to find that in New Hampshire. There are gestures in that direction, but couldn't sometimes a knowingly misleading the court plus other factors in equity be enough?
Yes, and what the
if that's true, then intent isn't essential. It's just one factor in your view.
So I agree it's
right?
one factor, but the intent that matters, Your Honor, is the intent to adopt inconsistent positions.
No, I get that, but not necessarily an intent to mislead the court.
Right. I mean, there's a lot of language in the cases about cold manipulation of the courts, plain, fast, and loose.
Yeah.
But really what I think that the court is driving at is intentionally adopting inconsistent positions. And what's different about this case is there's been no actual determination that the debtor here intentionally adopted the position that there's no cause of action.
Thank you, counsel. Justice Thomas? Justice Alito?
Well, excuse me, a little confused by those answers. So what is required is knowledge of the fact that inconsistent positions are being taken?
So I think Justice Alito, it's the fact that the debtor has taken intentionally inconsistent positions. So in the bankruptcy context, by failing to update the form, a determination would be made that the debtor in fact intended to adopt the position that no cause of action exists, as opposed to simply making a mistake in failing to update a form. And when the debtor then goes to a separate court and advances this cause of action, he's taking the separate position that the cause of action exists, and that would be intentionally inconsistent. But that intentional inconsistency doesn't arise where a debtor simply makes a mistake in failing to update a form. And in that situation, the debtor isn't adopting any position that he has no cause of action. He's simply making an honest mistake. And that's so.
I'm not sure I understand the distinction in this context, but I'll leave it at that. Does the record show why the bankruptcy attorney did not list this as an asset?
It doesn't, Your Honor. The bankruptcy attorney did, in a sworn declaration in the record here, say that my client informed him of it, but it doesn't explain why he didn't advise the court. I mean, that's something that potentially could come out in a holistic inquiry. But I think here what matters is the debtor's intent in terms of whether or not the debtor was attempting to hide.
Well, do you think that the client in a judicial estoppel situation is to any degree responsible for the actions of the attorney?
Certainly not in the normal sense that the court ordinarily would apply the client responsibly, Your Honor, because the key here is the debtor own intent in terms of whether the debtor was trying to hide anything, because it's the debtor who's going to a different court and asserting his cause of action. And so I think that that's a factor, and I think, frankly, the fact that the debtor here told his attorney promptly after the accident is a factor that cuts in his favor, that he wasn't trying to hide anything from the bankruptcy court. And there are many other factors that go to that, but what we really want is an opportunity for a holistic analysis that under the Fifth Circuit's rule we never got.
Would you disagree with the proposition that where there is a duty to disclose and a potential financial interest, and the person who has that duty has a financial interest in not disclosing, that creates a pretty strong presumption of the requisite intent or knowledge?
Not in this context, Your Honor.
No?
Because here, I mean, again, the brief by the amici former bankruptcy judges themselves, piggybacking on the American Bankruptcy Institute's own findings, emphasize that these forms are confusing, hard to follow, even with the aid of attorneys. So I think in this context, we're dealing with, by and large, relatively unsophisticated people who lack legal training or the like. All of that factors into the judicial estoppel analysis here.
There are factors here that seem perhaps confined to the bankruptcy situation and to the way in which proceedings are often conducted in bankruptcy court, which I think are not always, it's not always a forum in which very meticulous compliance with all the rules apply. But I don't quite understand why the bankruptcy attorney didn't disclose. I don't quite understand why the creditors here had no interest, apparently, in having this as an asset of the estate.
Well, the creditors
Can you explain what's going on? Is it just because this is Chapter 13 and it's just handled in a rather informal way?
So, Your Honor, I mean, that's part of it. I mean, here the creditors were paid 100% on the plan and ultimately were paid off. And if any creditor had any concern about the payments on the plan or how this asset would have affected the estate, they could have taken action in the nearly 1 year between the time when Mr. Keithley advised the court of the cause of action and before his bankruptcy was completed. And all of that would be part of the mix here, the fact that no creditors even complained. There's a debate in the law as to whether or not there was any interest available here. I mean, again, as the amici former bankruptcy judges explained, we don't think interest was available here, so the creditors were getting and did get everything they were entitled to in the bankruptcy.
Justice Sotomayor?
I don't know how much this personal injury, the lawsuit would garner, but the choice for the creditors was an unknown sum of recovery, some of which would have been paid to medical injuries and to supplement lost income versus the security of having full payment, correct?
That's correct, Your Honor.
And having the bankruptcy last forever without full payment.
That's correct. And creditors are uniquely situated to protect their own interests. If they thought anything wrong had happened or they had a stake in the cause of action, they would have acted here. No creditor objected.
Thank you.
Justice Kagan?
Mr. Garre, your brief speaks often of bad faith, of whether the debtor had bad faith in making these inconsistent representations. Are you equating that? You haven't spoken of it very much today. Are you equating it with the kind of intent that you have been talking about?
Yes. I mean, the courts refer to bad faith here in cases from here and there. I mean, we're not suggesting that this is an inquiry into whether there was an intent to defraud the court or anything like that. I think what the doctrine looks to is the intentional inconsistency, and where a litigant makes an intentional inconsistency to gain an unfair advantage through the courts. This court recognized in New Hampshire that undermines the integrity of the court, and that is sort of consistent with an intent to mislead the court often. But we're not suggesting that a finding of actual bad faith is necessary. Or part of the analysis.
But are you suggesting that this finding of intentional misrepresentation is necessary? This goes to Justice Gorsuch's question again, and also to the Chief Justice's when he opened, but he said, in the end, judicial estoppel is about the integrity of the courts. And aren't there circumstances in which, even though you couldn't find that kind of intentionality on the part of the debtor or the part of somebody else making the representations, still the integrity of the courts is on the line?
So I don't think the court has to rule that out. I think the courts, just as frequently talk about how judicial estoppel doesn't apply in the case of inadvertence or mistake. And we think in that situation where a party, because of a mistake, hasn't intentionally adopted a particular position, that there is not the same kind of threat to the judiciary. But this court doesn't need to say here that judicial estoppel is never appropriate in any situation in which a party makes a mistake. We think it's an important factor. The court recognized it in New Hampshire. Other courts have universally recognized it, and it's particularly important and applicable in this unique context.
Thank you.
Justice Gorsuch.
Very briefly, Mr. Garr. I take your point that you don't need to have an intention to mislead the court. You say, though, an intention to pursue inconsistent positions is required. I just don't see that in New Hampshire either. I see you have to take inconsistent positions, but I'm not sure I see that you have to intentionally do so. Am I missing something there?
So I think in New Hampshire on page 750, it talked about prohibiting parties from deliberately changing positions according to the exigencies. The court cited lower court cases like Scarano, which talked about...
It does cite lower court cases, but when it actually lists the factors, it just says inconsistent positions and deriving an unfair advantage from them on page 750.
But then I think that... I'm sorry, Your Honor.
No, go ahead, please.
But then I think when the court later, in applying the factors, says that courts have resisted application in the instance of mistake.
Yes, inadvertence and mistake. That we know to be true. That New Hampshire definitely does say.
Right.
And I guess that leads me to this. Judicial estoppel is kind of an off-branch of equitable estoppel and is a relatively new invention dating to, dates to the mid-19th century. For law, I guess that's new sometimes. And we have exactly one opinion on the subject, New Hampshire. That's it. We haven't developed a law very much yet. And I wonder whether you would be content with the following ruling, and if not, why not? We've said inadvertence and mistake is not a basis for judicial estoppel. The Fifth Circuit glossed that rule with one of its own, a bright-line rule that it's never inadvertence and mistake when there's a knowing omission and there's a motive. Would it be enough to simply say, we don't need a further gloss on inadvertence and mistake, this is an equitable doctrine, go back and do it again, looking at what we've said?
So that would be an improvement, Your Honor, but I think that what the court what the Fifth Circuit needs guidance on is that you really have to take this holistic analysis in terms of whether or not there was a mistake.
Yes, I'm giving you that.
Right.
I'm just simply saying their bright-line rule on what does and does not qualify as inadvertence and mistake is not what we've said in New Hampshire. Go back and try again. Maybe applying state law, maybe taking cognizance of the bankruptcy context, all of these kinds of additional concerns, but a very short and succinct opinion saying, look at New Hampshire.
So I think that would be fine. Obviously, the devil's in the details, Your Honor. But I think what's critical there is
I don't think there would be many details.
That the upshot would be is that in this instance, if the courts conclude that a debtor's failure to update a form was simply an honest mistake, that it would be inappropriate to apply judicial estoppel.
If it's inadvertent or mistaken. Yeah.
Yes.
Okay. Honest mistake. Okay. Thank you.
Justice Kavanaugh?
Is there any difference between a knowing inconsistency and an intentional inconsistency? I'm not sure about your answer to that.
I don't think so, Your Honor. But the point that's critical here is that a court has to determine that when the debtor failed to update his form, he was knowingly or intentionally adopting the position that no cause of action exists. And instead
so no daylight, just making sure.
Well, look, in the law, there probably is difference between knowing, willingness, intentional.
In this context, is there any daylight between a knowing inconsistency and an intentional inconsistency as you see it?
As a practical matter, I don't think there is. I will say that the courts have talked about intentional inconsistency. That's the language this court piggybacked on.
Well, I think that creates confusion, as Justice Gorsuch was talking about.
So, I think the intent language is well taken. If this court believes that the knowing language is more suited to the doctrine, I think that would lead to the same conclusion here, and that's what we're up here fighting for.
Thank you.
Thank you, Your Honor.
Justice Barrett? Justice Jackson?
So I'm noting that New Hampshire wasn't a bankruptcy case, and I'm thinking that maybe judicial estoppel is sort of a poor fit for this context, because even if there is an intentional omission, however we define that, the bankruptcy court has many, many tools, I think. This is sort of what Justice Sotomayor was alluding to solve that problem when it comes to its attention, and to prevent the estate from getting this additional asset seems to harm the creditors in ways that I don't think are consistent with the way we understand bankruptcy. So, I mean, in addition to Justice Gorsuch's solution, I suppose one thing could be to think about whether judicial estoppel is really the right remedy here.
So, again, I'm not going to quarrel with anything that results in the conclusion that judicial estoppel doesn't apply. But what I think is important here is what the bankruptcy court has control of these proceedings, and its actions or inactions should be an important factor in determining whether or not judicial estoppel is.
Do you know if there's ever a world in which, is it after the bankruptcy closes, if this information comes to the bankruptcy court's attention, is there nothing that could be done at that point? Or
so it can be reopened.
It can be reopened. So there's always an opportunity to take advantage of it.
And I'm not going to make my friend's argument. What I would say, though, is I think that the courts have assumed judicial estoppel is applied here because on the theory that the second court is being duped, so to speak, in the sense that there's inconsistent positions, and so it's a threat to the second court. But I think Your Honor's point is exactly right, that the bankruptcy context is unique and that there's an important role for the bankruptcy courts.
And the second court's proceedings are sort of completely independent, right?
Yes.
I mean, they're arising out of facts that have nothing to do with the bankruptcy.
Exactly. And that underscores the windfall that the defendant is getting. The defendant in the second proceeding has no connection to the bankruptcy, and yet the defendant walks away scot-free.
Thank you.
And that's not equitable in any sense.
Thank you, counsel.
Thank you, Your Honor.
Mr. Liu?
Thank you, Mr. Chief Justice, and may it please the Court. Oops, I spilled the water. That's a first. Judicial estoppel should apply only if the balance of equities supports it. In New Hampshire versus Maine, this Court described factors relevant to that balance. Those factors include whether a party derived an unfair advantage from the prior position, whether that position was the product of inadvertence, and whether judicial estoppel is consistent with broader public interests. Here, the Fifth Circuit made two errors. One is the error petitioner has focused on this morning. The Fifth Circuit reduced inadvertence to just two considerations, thereby failing to consider the totality of the relevant evidence, including evidence that petitioner reasonably believed that he had no duty to disclose his tort claim while a damages award was still a long ways off. But the other error is, in our view, even more fundamental. The Fifth Circuit effectively reduced the entire balance of equities to a single factor, inadvertence, thereby ignoring the interests of innocent creditors and the bankruptcy court's ability to undo any unfair advantage. Therefore, the decision below should be vacated and the case remanded. I welcome the Court's questions.
Mr. Liu, I'd like you to take a step back to New Hampshire. New Hampshire was quite a different case from this. New Hampshire involved litigation between Maine and New Hampshire over the boundaries. In two earlier cases, New Hampshire had accepted that the middle of the river was the boundary. And in the subsequent litigation, it changed and argued that the boundary was to the Maine shore. And what the court said, in Justice Ginsburg's opinion, was that you could not, to your advantage, change positions like that, and hence judicial estoppel. How does that fact pattern allow us to decide this case based on New Hampshire?
Well, you're right that the specific context of New Hampshire is far different from a bankruptcy case, whereas some justices have already mentioned the two proceedings, the bankruptcy case.
Well, I'm not as interested in the bankruptcy case. I'm interested in the fact that the litigation was between the same parties. between New Hampshire and Maine. Here, that you do not have that mutuality.
That's right. And I think what this points up is that for judicial estoppel to apply, the balance of equities has to support it. And in New Hampshire versus Maine, I think it was important to the balance of equities that you had two co-equal sovereigns that had been involved in the same litigation many years prior. That's part of the balance of equities. Our submission here is a court shouldn't blind itself to the balance of equities in this context either. I think what New Hampshire versus Maine teaches is there are two kind of essential elements of judicial estoppel. Those are the first two factors. You got to have inconsistent statements, and you got to have the first statement relied upon by the court. But beyond that, and this is on pages 750 to 756 of the court's opinion, it's a balance of equities analysis. You look to see if one party derived an unfair advantage. You look to see if the prior position was the product of inadvertence. You look at the broader public interest, including the fact that these were two co-equal sovereigns that were involved in the same case earlier, and you ask, after considering the entire balance of equities, whether judicial estoppel is appropriate. I think what's really wrong about the Fifth Circuit's decision in this case is if you look at PEDAP 9A, it reduced that entire balance to just one factor, which is inadvertence. And then beyond that, compounding that error, it turned inadvertence into just two considerations, knowledge of the facts and potential motive, which is not a totality analysis of even the one factor the Fifth Circuit thought it should consider.
Mr. Liu, I guess I'm not sure I understand how what you're saying right now fits with this footnote that you wrote. This is page 24 in your brief, footnote 2. Where you say we shouldn't talk about whether inadvertence always precludes judicial estoppel. And I hear you saying now we should talk about that. We should say inadvertence is just one factor. It doesn't always preclude judicial estoppel. Am I wrong about that there's a shift here?
I wouldn't say it's a shift in this sense, and I think there are two analytical things at issue. One question is what goes on the balance, and we think that is an important question the court should address. What goes on the balance is not just inadvertence, but also unfair advantage, other interests, et cetera. That's all what goes on the balance. I think there is a separate analytical question about how those various factors relate to each other. And what we mean by footnote 2 is this court doesn't need to decide whether one factor, if it exists, is necessarily going to trump the other factors. We think it's enough for this court to basically reiterate what it said in New Hampshire versus Maine, which is the balance of equities isn't just one factor, it's all these factors. The court said it was non-exhaustive.
But do you agree with this, that even if you had all the intent in the world, it doesn't necessarily get you judicial estoppel? And conversely, even if there was complete inadvertence, it doesn't necessarily preclude judicial estoppel?
That is the government's position. I think that's that second bucket of analysis. The court doesn't need to go that far. I think the court can just say, look, if you're a lower court, you should be looking at all the factors. It may well be that one factor turns out to be dispositive. After you've seen a bunch of cases, maybe you can reach that conclusion. But at this part of the analysis, you should at least have in full view all the relevant factors.
And is the idea behind this that everything needs to be filtered through the principal purpose of judicial estoppel, which is protecting the integrity of the courts, and that this question of intentionality may coincide with that principal purpose, but in certain cases may not? Correct.
We think certainly when a party has deliberately taken a prior position, as opposed to having taken it by inadvertence, it certainly heightens the impression that I think judicial estoppel is trying to avoid. And that impression is the impression that courts are just arbitrarily giving a party whatever it says it wants. But conversely, there may be cases where the first party gets a tremendous advantage, even though it took that position inadvertently, and it doesn't make sense, it just wouldn't be fair to allow that party to obtain a further advantage in the second proceeding.
Mr. Liu, I take your point that inadvertence and mistake may not automatically defeat judicial estoppel. But I'm also not sure we need to get into what all the factors are or even talk about a holistic analysis, given, as Justice Thomas pointed out, New Hampshire was, really could have been an equitable estoppel case, forget about judicial estoppel. And the bankruptcy context is different, and we have an Erie problem, and all these. Why not just simply say the factor of inadvertence and mistake, whatever it means, doesn't mean what the Fifth Circuit said it meant. Goodbye.
That is a sufficient ground for vacating and remanding.
And you have no problem with that?
We have no problem with that. We just wanted the court to be aware when it's considering the scope of inadvertence that it may not be the be-all, end-all of the analysis, that you might not necessarily hang everything in the case on whether it's inadvertent or not.
We don't even need to take a view on that, it seems to me. Maybe some future case that there'd be a reason to make it a bright line rule, or maybe not, as you say. We don't have to take a position in this case on that, do we?
That's right. And really our submission is you don't need to move the lines you drew in New Hampshire versus Maine an inch. New Hampshire versus Maine said inadvertence, it may be appropriate to resist application of judicial estoppel if the party's prior position was the product of inadvertence. We're happy with that statement of what the law is.
Thank you.
We dispute the way inadvertence was defined here.
Well, I mean, New Hampshire against Maine, it's featured prominently because it's the only thing. I wonder if saying anything about it, I mean, it's two sovereign states against each other and the boundaries. I'm not sure that we should try to bring it into play any more than is necessary.
I don't really quibble with that at all. I read New Hampshire versus Maine as setting forth pretty high-level principles. I mean, the principles I understand that decision to set forth are the balance of equities matters, and the list of equities is kind of non-exhaustive, and inadvertence may be one of those factors. I think at that level, there's nothing wrong with taking those principles and articulating them here. I agree, once you get into how those principles cash out, you may not be in a situation where New Hampshire versus Maine really speaks to that.
Thank you, counsel. Justice Thomas? Justice Alito?
I know I will have a chance to speak to Justice Gorsuch later, but you answered him.
I look forward to it.
I don't know what you think simply saying they were wrong about inadvertence would get us, because you came up here and said there were two fundamental errors, and that, and I thought, in describing the errors, both times you said the court failed to take into account totality of the circumstances. So it wasn't just merely their failure to address inadvertence properly. They failed to do the holistic evaluation of what was the prejudice to the parties from that inadvertence, even if it was deliberate. It could still. You've said all these other things, so I'm not sure.
Well, we would certainly be more satisfied with an opinion that went further and said inadvertence is not the only factor. We think that just follows pretty directly from New Hampshire versus Maine. To give one stark example, I mean, New Hampshire versus...
No, but why did you say yes to an opinion that basically brings us back here? Because I can see the Fifth Circuit saying exactly what it said below. If you know you didn't say it, it's intentional. It's not inadvertence. So they've already answered that question.
Yeah, no, so...
and so I'm not sure...
I don't think they... So this is getting to the error I think this court needs to correct, because it is core to the dispute between the parties, which is... This is the correct definition in our view of inadvertence versus non-inadvertence. We think in all cases the relevant question is, did the party deliberately take the prior position? In other words, did the party deliberately choose position X?
So does it come down to the Fifth Circuit now coming back to us and saying he told his attorney, but the attorney didn't tell the court, and you're responsible for your attorney's errors? Which is what we usually say.
We do think the attorney is responsible. The attorney's conduct does bind the client.
And so that's what the Fifth Circuit basically said here, that the attorney knew, the attorney didn't say it. So we're back to the...
Well, here are two errors I think the Fifth Circuit made just as to inadvertence. One is it deemed irrelevant, and this is on PEDAP 13A, any evidence regarding the attorney's knowledge of whether the duty to disclose applied in this case. That is a bucket of relevant evidence, relevant and mainly objective evidence in our view, that the Fifth Circuit didn't consider. And the second error is, even with respect to its analysis of the potential motive that Justice Alito brought up, the Fifth Circuit's analysis was incomplete. I mean, the record suggests many reasons why there was no modification of the plan when this tort claim was ultimately disclosed. The fact is, no matter when you disclosed it, it would have been years before this claim would have become an award of damages.
In one word, I'd do a simple opinion that says you have to look at the totality of the circumstances and you can't reduce it to the three factors that you mentioned alone. That would be my opinion.
That's right. And the Fifth Circuit ignored evidence relevant to the knowledge of the duty and ignored evidence pertaining to the potential motive prong that the Fifth Circuit did consider.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh? Justice Barron? Justice Jackson? Thank you, counsel. Mr. Jay?
Mr. Chief Justice, and may it please the Court. The question the Court agreed to decide in this case is not about whether there was a clear inconsistency between the representations, but about whether proof of bad faith is required before judicial estoppel can apply, and the answer should be no. Where the same litigant seeks to win a second victory on grounds that are clearly inconsistent with the grounds on which he won the first victory, that undermines the integrity of the judicial process. And it is not necessary to also prove that as Mr. Liu just said, that litigant intended to switch positions all along. I'd like to make basically three basic points, one about precedent, one about practicalities, and one about bankruptcy. The first is that there are multiple cases, not just New Hampshire, also the 19th century cases that New Hampshire addressed. I don't think petitioner's rule can explain any of them. One key thing that New Hampshire says is that mistake or inadvertence looks at time one, not time two. And I think there's been a lot of inconsistency with the other side's presentation this morning about whether they look at time one or time two. Second, in practice, as the district court noted, basically every litigant facing judicial estoppel claims his original position was a mistake. Under the other side's rule, just a declaration claiming a lack of legal understanding or that the attorney gave bad advice would be enough for a trial. And third, although we are not urging a special rule for bankruptcy cases, as the other side is, we think that our rule better fits the bankruptcy context anyway. Petitioner's rule would undermine the full disclosure of assets on which the bankruptcy bargain depends. A doctrine, as Judge Easterbrook puts it, that encourages debtors to be truthful in their bankruptcy filings will assist creditors in the long run. That is why our rule does not deprive creditors of recoveries that they would otherwise be able to get. District courts might well exercise their discretion at the margin in favor of less culpable litigants, but there's no reason to make bad faith a prerequisite. I welcome the court's questions.
Is there any difference between your rule and the Fifth Circuit's rule?
Not in practice, and certainly not in this case. The one, if I were writing the rule for all circumstances, I would say that the question of benefit, which the Fifth Circuit describes as part of the inadvertence or mistake inquiry, I think New Hampshire would put that earlier in the analysis. And the core, New Hampshire's core three factors are clear inconsistency, accepted by the tribunal, and getting some benefit that would be inequitable for you to keep. And I think that we would put the sort of the financial aspect of the benefit that the litigant gains from the bankruptcy in that bucket instead. I don't think that's an analytical point. I don't think it makes any difference in this case. So we certainly agree with the Fifth Circuit that the question is not whether the litigant himself got bad legal advice or was subjectively aware of the legal duty as opposed to the facts.
New Hampshire also considered the detriment to the party before the court. in the subsequent litigation. What is the detriment to your client?
So in New Hampshire, the court said or, in other words, that it said either benefit to the party that took the position or detriment to the adversary. And I think New Hampshire is unusual, and your question to my friend earlier about mutuality gets to this. It is actually unusual for judicial estoppel to come up in second piece of litigation involving the same parties, precisely because if it's the same party, they're well positioned to call the person out for switching positions. In the Philadelphia Wilmington Railroad case that New Hampshire discussed, it's been settled since the 1850s that this is primarily a doctrine about defending the court's integrity, and for that reason, mutuality is not required.
How would you respond to petitioner's argument that this is a windfall for your client?
I think it's just the same point, that the way in which courts' integrity is preserved through the use of this doctrine is that the litigant against whom the inconsistent representation is being made points it out to the court. And so in that sense, because mutuality isn't required, it is that litigant standing in for the court and pointing out that the court is about to be misled by the common litigant who took the clearly inconsistent position in the prior action. So I understand the windfall point, but I think that's just, you might say the same thing about res judicata collateral estoppel, that the system cares more about locking down the first determination and preventing it from being relitigated rather than saying, well, the correct answer would be to side against the second litigant rather than the first.
Well, but it's not really just relitigation. It's a new person jumping onto the scene. It does seem, in terms of the court's integrity, it does seem a little much that the one person who's getting off is the one whose truck hit the other guy, right? I mean, it's a lot easier to explain why that's a bad result than simply the idea that, there was something else that went on that the court didn't know about, and now you're going to change the natural sense of the propriety of the result by saying the one person who we know inflicted harm, according to the allegations, of course, gets off scot-free.
So I think that's a consequence, Your Honor, of the fact that if this comes up, it comes up at a time when it's too late to reopen the first proceeding. And this goes to a question that Justice Sotomayor asked, that one of the elements of judicial estoppel is that the first proceeding has already resulted in some benefit to the common litigant. And so every court of appeals that has applied New Hampshire to the bankruptcy context has agreed with the basic proposition in this case, although I think it's one that Mr. Garr seems to be disagreeing with, that a representation to the bankruptcy court that there is no cause of action is inconsistent with asserting in a subsequent action that there is a cause of action, just like asserting ownership of a piece of property or a different legal interest. Asserting that you don't own that property in one action is inconsistent with trying to invoke the ownership right in a second action.
Yes, it's inconsistent, but what is the advantage that is gained from that in this situation?
So the advantage in a bankruptcy in which the debtor has an incentive to minimize assets is the ability to convince the bankruptcy court that, so this is a Chapter 13 case, that taking this as an example, that a Chapter 13 would be just as much in the creditor's interest as a Chapter 7, which is always the...
I understand, but the bankruptcy court could convert the proceeding if that information is brought to their attention. The creditors apparently in this case, for whatever reason, said, we don't care. I don't understand what the advantage is that is being apparently at the heart of your concern that judicial integrity is threatened or something in this situation.
The advantage that a litigant gets is convincing the bankruptcy court to confirm the Chapter 13 plan.
Not a litigant, this litigant. In other words, in these circumstances,
sure.
Because, as others have pointed out, we're talking about a totality of the circumstances, equitable assessment of whether judicial estoppel should be applied.
Right. And if you want me to talk about the facts of this case, so in this case, at the time that the debtor had the cause of action, the debtor also fell behind on payments and had to submit additional amendments to or modifications to the Chapter 13 plan. And the trustee initially objected to the first of those amendments and said, this amended plan doesn't leave unsecured creditors as well off as a Chapter 7.
And once the information was brought to their attention, no one sought interest, no one thought the plan should change in any way.
So respectfully, Your Honor, look, that's a distinct point, and I'm happy to address that because this was brought to the bankruptcy court's attention such as it was. And if you look at page 203, you'll see that the debtors didn't actually disclose any valuation for this claim. They didn't change the sum total of their assets at all. They just listed, they mentioned the claim and said unknown. This, of course, was well into the payment plan. It's after the new confirmation had been granted. And at that point, I think it's not surprising that creditors who were receiving this stream of payments and weren't really told anything about this cause of action didn't affirmatively seek reopening of the
I guess
bankruptcy.
My question is it fair to just assume or presume that by not having this information, an advantage has been obtained such that it makes sense and is equitable to preclude the debtor from accessing or having this asset, which could, in some situations, actually go into the estate and be a part of the entire bankruptcy? It just seems very harsh.
So I'm happy to answer the question, and I just let me note by way of preface that whether there has been an advantage gained, I think, as this went to my colloquy with Justice Thomas earlier, I think that's a different question than the one on which the court granted cert. I mean,
well, we certainly didn't grant cert on the bad faith. You said that at your original statement, and I took issue with it. The question the court granted cert on, you said, was whether proof of bad faith is required.
Right.
If we look at the actual question presented, it's whether the Fifth Circuit's formulation, which is requiring potential motive for disclosure, was correct.
Right, but if you look at the last sentence of the question presented, it says that the reason that the Fifth Circuit is wrong is that it doesn't require proof of bad faith, and that is the fundamental submission that we're making to the court, that inadvertence or mistake, as an exception to the judicial estoppel doctrine, does not connote proof of bad faith. I mean, it may.
Well, Mr. Jay, if we're talking about protecting the integrity of the courts, I just want to clarify a factual point. Am I correct that the bankruptcy court declined to sanction?
No party asked for sanctions, Your Honor. So that
the bankruptcy court knew because this was brought. Let's see. It is my understanding that the bankruptcy court knew about this because he ultimately did go back to the bankruptcy court and make the court aware. Am I right about that?
There's an amended schedule that, as I was saying to Justice Jackson, doesn't disclose the amounts, but states that there is a claim, for the first time, that there is a claim in the answer to question 33 on the schedule. That's after the confirmation.
And maybe this goes to Justice Sotomayor's point and Justice Jackson's point to your friend on the other side. Why isn't the bankruptcy in this context, why wouldn't we expect the bankruptcy court to be the one to police this?
I think that no one asked the bankruptcy court to take any action, and it may well be that, as I was saying to Justice Jackson, that the creditors concluded that this late in the payment plan, it wasn't worth the candle to do so. And the bankruptcy court, and this to the point that Justice Jackson asked my friend about, the bankruptcy court may have tools that it can use in bankruptcy in the sense of denying a discharge or denying access to Chapter 13 and forcing the case to be converted to Chapter 7, or even referring to criminal prosecution. But all of those things go to the bankruptcy itself rather than to the consistency of the representations between the bankruptcy and a subsequent proceeding.
If we might zoom out just for a second, judicial estoppel is an off-branch of equitable estoppel. Equitable estoppel requires mutuality. Our judicial estoppel one case had mutuality where a benefit gained by one party did cause a detriment to the other. Could have been an equitable estoppel case. This is where we don't have mutuality. And if judicial estoppel is about protecting the integrity of the courts, I get the concern on the one side that there's perhaps a misrepresentation of the bankruptcy court, subject to all the caveats we've discussed. But the courts also have a duty, and they're open to claims of personal injury. And to give your client a windfall would also seem to have some impact, again, zooming out, on the integrity of the judicial process and its accessibility. No?
I don't think so, Your Honor, any more than issue preclusion does, which, as the court.
No, I understand we have non-mutual issue preclusion, right. and you alluded to those, but those doctrines are, again, new and riddled with exceptions when it comes to non-mutual collateral estoppel and the like. And it does seem to me like often we don't do it when it's just not fair. And here, how about, again, if we're concerned about the integrity of the judicial process, why isn't one consideration that your client would just get a plain old windfall?
So the non-mutuality goes at least back to the Philadelphia-Wilmington Railroad case in the 1850s, which discussed in New Hampshire, right? So I resist the premise that it is as new as, for example, non-mutual issue preclusion.
Okay, I take the point.
Right, and the significance that we take from the fact that, as you said, judicial estoppel grows out of equitable estoppel is that equitable estoppel likewise doesn't have this type of state of mind requirement. It focuses on
put aside the state of mind requirement. Put that aside. That's right. Not relevant to my question.
But I think that the reason that there is no state of mind requirement for equitable estoppel or judicial estoppel is that both doctrines focus on the effect. Equitable estoppel focuses on the effect to one litigant. Judicial estoppel focuses on the effects on the judicial system.
Yes, and my question is, one of the effects on the judicial system here is we're closing the courthouse doors to a good claim and allowing one party who is engaged in tortious conduct to walk away scot-free.
The premise of your question, Your Honor, that it is a good claim is.
Let's assume. I know you resist that, but let's just assume that.
I'm not resisting it for the usual. Lawyers don't concede anything. Reasons. I'm resisting it because it's the very premise of judicial estoppel that we don't look past. Once the first case is over, we don't look past the accuracy of the representation in the first case. That's the point. Right? The whole point of the representation in the first case, whether it's New Hampshire or this bankruptcy case or any of the other judicial estoppel cases, is the representation that, in this case, I don't have an asset of this nature.
Thank you.
Right. So I think that Mr. Garr, in his presentation, brought this, back to the sort of the mantra of a failure to update a form, and I do want to resist that characterization because, again, first the court didn't grant cert on the clear inconsistency point. There's no disagreement in the courts of appeals that where there's a representation that a cause of action doesn't exist, that's inconsistent with asserting it. And in this case, there's no assertion of a factual lack of knowledge. In fact, the facts show that all the facts were known. There's also no dispute about the obligation to disclose. And this gets to a question I think that Justice Alito asked my friend earlier, that where there is a duty to disclose, that failing to make a disclosure is a representation to the courts that there is nothing to disclose. So because those aren't the questions before the court, all I think that the other side is left with is saying that they resist the idea that either the attorney knew of the legal obligation, which in that bankruptcy court is well established, it's been established for at least a decade, or that the attorney failed to give advice on that to the debtor. And on tying together all of the questions about what you might say in an opinion, we would urge you to say in an opinion that that attorneys' representations matter, that a litigant can't escape judicial estoppel by saying, although my attorney made this representation to the court in the first action, that's a mistake because I didn't understand the consequences of the choice that my attorney was making. That's fundamentally inconsistent with the notion of mistake as this court has used it for well over a century. I think this is well fleshed out in the German versus Carlisle-McNally decision that we cite in our papers. But that cites precedent going well back to Justice Story, construing a statute involving mistake or error. Legal mistakes aren't that kind of mistake. And that type of error is not what the judicial estoppel doctrine or the inadvertence or mistake exception to it are getting at. And I think Justice Jackson had the hypothetical in the top half of the argument about the asset being concealed from the divorce. And I think that the point that I wanted to make from that is that how is that example going to come to light, and how are these causes of action that are not disclosed in bankruptcy, and that if disclosed, the bankruptcy court could make its determination about whether they should have been disclosed sooner and what the consequences should be. How are they going to come to light if there is no incentive to litigate the fact that they didn't come to light sooner? So as the lower courts have recognized, that apply our rule, not just the Fifth Circuit, but also others.
But why does the incentive have to come from the threat of not allowing you to pursue the claim? I mean, this is the point that many have pointed to or made with respect to all the tools the bankruptcy court has to sanction an intentional omission of that nature.
But the tools to sanction all presuppose that someone's going to find out about the concealed claim. And the tools are not useful if the assets don't come to light.
Yeah, but you need to find out about the concealed claim in order for the claim to be extinguished. I mean, that's a necessary condition for anything to happen. The question is why, once we find out about it, the remedy is to say you cannot pursue that claim as opposed to some other solution.
I mean, I think the reason is the clear inconsistency. I mean, and this doesn't just come up in the context of the good claim that we're talking about. I mean, this comes up in all types of bankruptcy actions in which party makes a solemn representation to the bankruptcy court about the amount of property that they have, and they subsequently turn around and make representations to another court that are flatly inconsistent with that.
I understand, but the equivalent would be that once that happens, somehow the bankruptcy court could divest the person of that property, which is not the answer, right? The answer is they adjust the bankruptcy proceeding to sanction them appropriately.
But that's just it, Justice Jackson. I think that once the plan is confirmed and the debtor gets the discharge, I don't think that my friend on the other side is correct to say that the bankruptcy court always has the option to say, oh, I'm going to take some further action. In a Chapter 13 plan, if the creditors have been paid off, then the creditors have been paid off. And a Chapter 13 plan is time limited. The bankruptcy court, I think, doesn't have the free hand that your question is positing.
And should that factor in then to whether or not judicial estoppel is appropriate? Why couldn't, in the totality of the circumstances, maybe in that situation you would have judicial estoppel?
So I think I resist giving a bankruptcy-specific answer, but I'm happy to give an answer for that question. In every judicial estoppel case, rather, the question is, what is the benefit that the common litigant, between the two actions, has gotten from the first action? And if it's raised early enough that the litigant can surrender the benefit, then there isn't going to be judicial estoppel. I think that's just baked right into the doctrine. You don't need a bankruptcy-specific rule to say that, because I think that's part of judicial estoppel, just like the clarity, like the clearness, how clear the inconsistency between the representations is also baked into the judicial estoppel doctrine. And when there's doubt about whether a pro se litigant or something like that has made such a representation, then the existing judicial estoppel doctrine can deal with that.
Thank you.
Unless the court has any further questions?
Justice Thomas? Thank you, counsel.
Thank you, Your Honor.
Rebuttal, Mr. Garr?
Thank you, Mr. Chief Justice. We would welcome any ruling setting aside the Fifth Circuit rule in this case, but we do think it's important for the court to say that a holistic analysis should be undertaken into intent, because I do think that it's likely this case will end up right back before this court, as Justice Sotomayor indicated. And then we would urge the court to let the lower courts sort out the particular facts and circumstances, in this case under the holistic analysis. As to the question presented and the whole petition is directed right at the Fifth Circuit's rule here. There's absolutely nothing that prevents this court from considering that question, resolving the circuit split, and the court should do so. Petitioner disclosed his claim with more than a year left on the bankruptcy plan. In this case, the bankruptcy court could have objected if it thought anything was awry, and any creditor could have come forward and objected if it thought it was entitled to anything more. But no one did. And last, I would just say on the windfall point, No doctrine of equity would allow the tortfeasor in this case to walk away scot-free if the debtor here simply made an honest mistake in failing to update the form. The Fifth Circuit's decision should be reversed and the case remanded. Thank you.
Thank you, counsel. The case is submitted.
Someone who legally comes close to the border, and why would Congress privilege someone who illegally enters the United States? Can you answer that directly?
I think it's a bit unfair to say that we're privileging people who illegally enter, because people who legally enter are being treated better than people who illegally enter.
I got that distinction. The distinction is between the illegal entrant and the person who lawfully gets very close and wants to follow the rules. That person is disadvantaged as compared on asylum as compared to the person who illegally enters. And the question, as I understood it, is why would Congress do that? So what's the answer?
Two answers to that. The first is we would deny that the person is being privileged, because metering is not saying to the person, the polite asylum seeker, in Justice Jackson's words, you can never enter the United States and your only option is to enter illegally. It's saying our port is at capacity today, try again some other day, and that time when that person comes in, that person could come in legally. The second answer is that Congress could reasonably determine that the United States has greater responsibilities to aliens in the United States than to aliens in Mexico. That's how sovereignty is divided among nations in the world, and whether you got here legally or illegally, Congress could say we have greater responsibilities once you're within our borders.
More generally, or separately, I guess, what is the problem, what was the problem that was trying to be solved here when this policy was put in place?
The policy was put in place in 2016 when ports which might have a capacity of something like 50 or 100 people, holding capacity of 50 to 100 people, were facing lines of aliens far larger than that. And those individuals were demanding entry at that particular time, and ports were overwhelmed. Sometimes they didn't have enough food to feed the people arriving in the United States. Sometimes they didn't have beds in which they could sleep. They didn't have places where they could hold them. So it was necessary for the ports to say, sorry, we're at capacity, try again some other time. And I think respondents' position is that that is categorically illegal in any circumstances, because it always violates the asylum statute and the inspection statute to say we're full right now.
That's not quite what they're saying. It's certainly not what the circuit court said. What the circuit court said was we have a law that permits the United States to have people reside in Mexico or stay in Mexico while the application is being considered. So there is already that remedy for the government, correct?
There is a contiguous territory return provision, but
exactly. And what the circuit said is it's okay for you to say stay somewhere else while we process this. What you can't do is do what the statute doesn't permit you to do, which is not to inspect me at all. The circuit said you can make a list of people and have a rational basis to tell them to come back in a particular time. But instead what you were doing was saying, you alien, we're not going to even consider your application. We're not going to take your number. We're not going to do anything. We're just going to turn you back. We're going to be the ship on the MS Lewis and ship you back to be killed wherever you end up. And that's what the statute doesn't permit. Now, you mentioned—
Can I answer that?
Yes.
That's an argument that SAIL was wrongly decided, because that's exactly what the United States was doing in SAIL, shipping people back to Haiti.
No, because SAIL made very clear that the UN obligation is if you're a refugee who's arriving at the port of entry, if you're knocking on the door and I'm staring you in the face, you have an obligation to at least listen to my application. And you can tell me to wait, you can put me in a safer place to wait, you can do a bunch of different things. What you can't do is just turn me back from the border?
And the second answer is we're not shipping people back to Haiti or whichever country the person might be
No,
coming
you're just
from.
telling them walk back.
No, we're
So
not
they
telling
can,
them anything.
the people on the St. Louis could have swam back. They happened to be on a boat. But that's what we did. They were off the coast of Florida, and we didn't let them dock. We didn't let them dock and take and interview them at all. We didn't consider whether they were being persecuted. And the majority of those people were shipped back or had to go back from where they came and were killed. That's what we're doing here, isn't it?
Like the court in Sale, I do not deny the moral weight of claims made by refugees, but that is not the question before the court. The question
would you complete your answer?
The question before the court is what obligations did Congress impose in the asylum and inspection statutes, and those refer only to aliens who arrive in the United States.
May I ask you a question about the statute and about that answer? I totally get that if you just look at the language who arrives in the United States, it sort of suggests, well, you have to be in the United States. So totally get that. It does seem to me that this statute, you don't have to be a superfluity hawk to think that this statute has a massive superfluity argument, problem. Because the way you're understanding that second phrase, the statute ends up saying essentially any alien who is in the United States or who was in the United States. So what led to that kind of superfluity in this statute, and how are we to understand it? It really, if you just sort of, it can't mean that, so the in the United States must mean something else.
I agree that the arrives category is a subset of the present category, but there are a few different reasons why Congress might have mentioned that subset, the same way it mentions subsets in other statutes that refer, for example, to money or property. One reason is that the arrives category is subject to special rules that other applicants for admission are not subject to. For example, they're automatically subject to expedited removal if they are inadmissible. So when the statute 1225 is talking about the arrives category repeatedly in later provisions, it makes sense to mention them separately in the definitional provision. The second reason is that immigration law has historically drawn a distinction between deportation proceedings for people in the interior of the United States and exclusion proceedings for people who've just arrived in the country. This provision, in this provision, Congress might simply have been trying to make clear that both of those are covered. The third reason is that under the entry fiction, this court had previously interpreted terms that are close synonyms for present in the United States, like found in or within the United States, to exclude recent arrivals. And Congress might have wanted to make clear that it's covering recent arrivals as well. So for all those reasons, the arrives category serves important clarifying function.
It also serves a sort of confusing function. When Congress did this, it must have realized, or you would think it would have realized, that it was just going to confuse matters to essentially say the same thing twice about an alien who was in the United States. I don't think on the entry, what is it called, the entry fiction? I don't think you would have needed this second provision to do that, because you have physically present that should have tipped people off that we're not talking about the entry fiction. And we also have the language about irrespective of the alien's status, which also should have tipped people off that we weren't talking about the entry fiction. So if I took that to be your primary argument in the brief, and I don't think it really sort of does it.
Well, if you're positing that there are already two parts of the asylum statute that are meant to address the entry fiction, then it isn't much of a stretch to say that there's a third piece as well. Secondly, the two pieces you've mentioned are not included in.
It's like belt and suspenders and, whatever, a new pair of pants.
And the second point is those two pieces are not in Section 1225. They're only in Section 1158. So if Congress had included the phrase arrives in 1225 but omitted it from 1158, then people might draw a negative inference from the inclusion in one provision and the exclusion in the other.
Can I just ask?
Can I ask you, does the administration, the metering policy has been rescinded? Does the administration intend to reinstate the metering policy if it's successful in this case?
The administration would like to be able to reinstate metering if and when border conditions justify. I cannot predict in advance what border conditions will look like or what specific policy responses the administration would take in response to that.
So, Mr. Suri, why then aren't we just issuing an advisory opinion in this case? I mean, your back and forth with Justice Sotomayor raised another line of questions that I had along the same lines as what Justice Barrett just indicated. At the time in which the district court in this case issued its opinion, the metering policy had been rescinded, and as you've now represented, the government has no concrete plans to reinstate it. So I don't understand what we are doing other than advising the government in sort of the abstract as to whether or not this kind of thing is lawful. We don't have an actual policy. We don't know who's right as between you and Justice Sotomayor about what metering actually contains because the government doesn't have a policy in effect and hasn't shown us that it wants to have a particular policy. None is on the table. So how do we even have jurisdiction, really, to be addressing this?
The question of mootness turns on whether the court can grant any effectual relief whatsoever to the prevailing party. You can grant us effectual relief, and the case isn't moot, because there are three types of prospective orders that the district court issued that are still in place against us, the most important of which is a class-wide declaration saying we can never engage in metering at the southern border. If you agree with us, you would lift that declaration, and we'd be able to resume metering. Therefore, the case is not moot.
You don't have a plan to resume. I mean, are you suggesting that? I'm a little worried about the judiciability in the following sense. At the time the case was initially brought, there was a policy in place. The government was engaging in metering, and obviously we had a live controversy about it. But before the district court issued its opinion, that policy was rescinded. There was no more metering, and yet I think in the record it demonstrates that the parties just sort of said to the district court, well, it would be helpful if you would go ahead and enter your ruling. That's ordinarily not the case, that you don't just have the district court opining on policies that are no longer in effect. So I appreciate that the district court did, and so you would like to get rid of the order, but why wouldn't the right remedy be to just vacate the order rather than having us speak to the merits of it in this way?
If you'd like to look at the issue through the lens of voluntary cessation, you get to the same result. Yes, we voluntarily ceased metering at one point.
There are no findings about voluntary. The district court did not make findings about voluntary cessation, so I don't know how we could go there.
But the test under voluntary cessation is it absolutely clear that the conduct can't reasonably be expected to recur? And that can't possibly be satisfied here because we're telling you we want to do this policy again if border conditions justify it.
Thank you, counsel. Justice Thomas? Justice Alito?
During the period when metering was suspended, what would happen in the hypothetical situation or not so hypothetical situation you were talking about where a port was capable of handling, let's say, 50 aliens and instead 300 wanted to enter? What was done?
What was done during the previous administration differed from what was done during the Obama administration. During the previous administration, the aliens were generally paroled into the United States. And the current administration has serious concerns about that approach as a policy matter because that means that individuals who may not necessarily be entitled to asylum are allowed to enter the United States without showing that they have a valid claim, and it may be years before the person can be found and deported if that is appropriate.
Do you happen to know how many people were paroled?
I don't have an exact number on that, but it would not surprise me if it was in the millions.
Thank you.
Mrs. Sotomayor?
Counsel, the Office of the Inspector General issued a report that said that some of the metering that was not done because of lack of space. it reported on the fact that there were empty beds in at least 2 ports, okay? So Justice Alito assumes the moment in which there were not enough space, but there is a claim that at least one president was using this as a subterfuge for ignoring any inspection whatsoever. Do you have a response to that?
Yes, I have 2. The first is that we dispute those facts, and this is at the summary judgment stage, so you can't resolve those disputes in respondents'
But we do have an Office of the Inspector General report that says that, correct?
True. The second answer is that respondents brought 2 different types of challenges to metering in the lower courts. First, a facial challenge saying metering is never okay, even if done for a legitimate reason. That's the only one before you today. And they also brought an arbitrary and capricious challenge saying even if metering is acceptable when the port is actually overcrowded, you can't use it as a subterfuge. That's not before you today.
All right. The language at issue here was passed in 1996. In 1998, the government modified its regulations to define an, quote, arriving alien as an applicant for admission coming or attempting to come into the United States at a port of entry, which is consistent with the policy that had been followed since 1980, I think it is, when the Refugee Act was passed, correct?
Not correct. The courts said in Cardozo-Fonseca, when it was talking about the 1980 Refugee Act, that the asylum statute applies only to aliens in the United States.
But the regulations have always been treating aliens who knock on the door at the port of a legitimate port of entry, have up until the metering policy, were at least giving them the opportunity to claim asylum, correct?
I'm sorry, that's not correct either. The regulation refers to an applicant for admission, and an applicant for admission.
All right, we're back in the same circle.
Yes.
All right.
Justice Kagan?
I'm going to take you back to the statute, Mr. Surrey, and the superfluity problem. You said to me the second phrase should be viewed as a subset of the first, and I want to understand what you mean by that. What does the first include that the second does not?
It includes individuals who may have arrived in the United States a long time ago, but the process of arrival has been completed. The person would be present in the United States, but the person doesn't arrive in the United States.
Is that really what you're saying? Is that your best? Because it strikes me that that's actually a better argument than the ones you've given so far. That the first phrase is people who have been here for some time, and the second phrase is meant to refer to people who sort of may arrive right now after this statute has gone into effect.
If you're intent on giving these provisions non-superfluous meanings, then we think that's the right way to go.
Well, that's a good thing to be intent on. I mean, because this is really not like a kind of, like Congress didn't see that it was doing the same thing in 2 different parts of the statute. I mean, these phrases are like right next to each other, and they must have meant, if you're right about what arrives in mean, I'm looking for a theory as to how that doesn't repeat what the first phrase does.
It's a subset, but that's different from saying that it has a completely different meaning and includes people who don't fit in the first
I got
category.
that, but you're essentially saying that the second phrase is a subset that's meant to respond to the fact that they've just put in a provision for expedited removal, which focuses on the same group of arriving people,
correct,
right? And that the first provision does not really focus on this expedited removal group of arriving people, but instead applies as well, although it also applies to them, and honestly, Congress didn't really need it, but applies as well to people who have been, sitting in Kansas for the last 5 years.
It could refer, for example, to someone who comes here on a visa. The visa expires, but conditions in his home country have changed while he's been in the United States, and so now he wants to apply for asylum. He isn't in the arrives category, but he is in the present category.
Thank you.
Justice Gorsuch. Justice Kavanaugh.
Is it lawful to impose the metering policy for the government to do that, even if a port is not overwhelmed?
We believe that it is lawful, but we're not asking the court to go that far today. The only issue before the court today is this facial challenge to metering, that it always violates the inspection and asylum statutes. There are separate claims that it would be arbitrary and capricious to engage in metering as a subterfuge, but that's not the issue.
Okay, it wouldn't be a statutory issue. It would be an arbitrary and capricious issue then.
That's the claim that's been raised by the other side.
Okay. And you make an argument, this is a relatively minor point, but it's in your brief, and I didn't agree with it, so I'm going to bring it up, which is page 25. You say that because it's in a parenthetical, it's different than if it had been separated by commas or dashes. Do you really mean that?
Yes, I
mean, I know we have a case in a particular context that once said that, but I don't know that that's a general rule that parentheses are different than dashes in interpreting statutes.
I recognize that you dissented in the case we're relying on.
Yes. But do you think that's a general proposition, that parentheses are different than dashes or commas in interpreting statutes?
Not that they're different in that sense, but that they convey an aside, and that material in parentheses, or for that matter even in dashes, don't override unambiguous language outside the parentheses or dashes.
Or commas?
I think commas grammatically.
I just don't want this. I mean, I was surprised to see this, and the Constitution has things in parentheses, and I'm just trying to make sure that this doesn't expand.
The court does not need to rely on that argument.
Thank you.
For us.
Okay.
Justice Barrett.
Mr. Suri, when I asked if the administration intended to reinstate the metering policy, I didn't intend to suggest that it was formally moot. And it was my understanding, I just wanted to clarify it, that the injunction in this case still has continuing effect on members of the class because it still matters.
That's right. There's a declaration that has continuing effect as to the whole class. There's also an individual injunction that has continuing effect as to one particular plaintiff, Beatrice Doe, whom the district court ordered us to allow into the United States, and that's an additional basis for avoiding any mootness concerns.
And that's why the Ninth Circuit said it wasn't moot.
That's right, and that's presumably why the other side hasn't raised a mootness argument, and why, even though we discussed mootness in our search stage papers, the court still granted review.
Thank you.
Justice Jackson?
So under Atchison Hotels, why wouldn't we still not reach at least the injunction, because Mrs. Doe apparently has represented that she does not intend to return to the United States, and the injunction is specifically requiring the United States to facilitate her entry.
In the Atchison case, the plaintiff dismissed that plaintiff's claim and told the court that the plaintiff was abandoning her claim entirely, and acquiesced in vacatur. There's nothing
she
like
she would have to do more, you're saying, than to say, I'm not coming back to the United States.
I think it's far too late to do any of that now, because we also have the class-wide declaration that independently keeps this case live.
Right. Let me talk about the class-wide declaration. You're asking us to reach the merits of whether or not metering is lawful and reverse the district court's judgment on that basis. Why isn't vacatur a permissible remedy here? I mean, I understand you'd like us to say today metering can be done, give you the okay to do it. But another way to address this, I would think, given that the district court declared a policy unlawful even though the policy was no longer in place, and the government today is saying it has no concrete plans to reinstate it, and the district court issued this order without making any findings about whether or not a live case or controversy existed, I think one could argue that the district court at least abused its discretion by nevertheless entering this broad declaration. So it would solve your problem, I think, if the court on those grounds just vacated it.
No,
why need we get into giving you an answer on the merits of the question of whether or not metering is lawful?
The Ninth Circuit reached the issue of mootness and issued a ruling on that issue. I think it's the first footnote in its opinion. So unless you determine that that mootness holding was wrong, there's no basis for disturbing the Ninth Circuit's decision. And on mootness, we think the Ninth Circuit got it right. This case isn't moot because we'd like to reinstate metering and we're being prevented from doing so.
But you don't have a concrete plan. I just want to make clear.
Concrete plans are necessary for standing.
For standing.
Not for mootness.
All right. Let me just ask you one question about your response to Justice Kagan. You were talking about the various reasons why Congress had arriving in this statute, and that one of them, you said, was the fact that there was previously a distinction between deportation and exclusion, and that Congress was trying to ensure that that was also covered, or that the principles related to deportation and exclusion were covered by this new regime. My understanding is that exclusion applied to people who were, quote, at a land border, at a port. But your reconceptualization of what arriving in is doing does not allow for at a land border or at a port. And so can you help me to understand how Congress could both be attempting to ensure that those principles were included, but we still agree with your reading of the statute?
The phrase at a land border in this context refers to people on the U.S. side of the border rather than the Mexican side of the border, and we know that in two ways. The first is the court's entry fiction cases, like Kaplan against Todd and Leng Mei Ma, repeatedly refer to aliens on the U.S. side of the border who've just arrived.
In the entry fiction context, but we don't have a case or a scenario in which Congress makes clear that it's responding to the entry fiction when it uses the words arriving at, right?
And the second answer is that in Cardozo-Fonseca, when the statute said at a land border, the court understood that to refer to aliens in the United States.
Thank you.
Thank you, counsel. Ms. Corcoran.
Mr. Chief Justice, and may it please the Court. In the 1980 Refugee Act, Congress established a statutory process for non-citizens fleeing persecution to seek protection in the United States. Congress designed the scheme to track the United States treaty obligation not to refoul refugees to territories where their life or freedom would be threatened. Because refoulement includes, to quote Sale, defensive acts of resistance or exclusion at the border, the Act requires immigration officers to process claims not only for non-citizens already present in the country, but also for those arriving at ports and elsewhere along the border. For decades, port officers followed the statutory procedures designated by Congress for inspecting and processing arriving asylum seekers. It was not until 2016 that the government asserted for the first time that it can wholly avoid these mandatory duties simply by blocking asylum seekers just as they are about to step over the port threshold. Petitioner's theory of the statutory text isolates the word in at the expense of making the rest of the statute nonsensical. By petitioner's account, the phrase arrives in the United States has no meaning not already covered by present in the United States. Arrives means already arrived, and amendments that Congress intended to encourage non-citizens to lawfully seek admission in fact did the opposite, permitting border officers to effectively eliminate access to asylum at ports. Petitioner's position is also at odds with the original public meaning of the provisions, reflected in the government's longstanding inspection practices at the time of IIRA's enactment, and in the government's own regulations, which have recognized for nearly 30 years that the Act's inspection and processing duties apply to non-citizens, quote, coming or attempting to come into the United States at a port of entry. As this court observed in Thorasagam, Congress carefully crafted our asylum system to ensure that the United States lives up to its ideals and its treaty obligations towards non-citizens fleeing persecution. The turn-back policy flouted both, and the Ninth Circuit was correct to deem it a withholding of the government's statutory mandates. I welcome the Court's questions.
How would you distinguish this case from Sale?
Yeah, this case is distinguishable from Sale in a number of ways. One, Sale involved the withholding provision alone. It didn't involve the statutory mandates that are at issue here in 1225, the inspection and processing mandates. So here we have a 7061 claim about whether the government has withheld compliance with those mandates. Sale is also different from an extraterritoriality and a treaty perspective because it involved interdiction on the high seas, which, as Sale explained, is outside of the jurisdiction of the United States, so it raises a host of questions that aren't raised here. I'd be happy to address some of the points my friend made.
Could you address 1157?
Yes. So 1157 is the refugee program. My friend takes the position that we have collapsed the distinction between the two. Our position reflects the way that 1157 and 1158 operated from 1980 to 2016. So for 36 years, no one was concerned about the distinction being collapsed, and that's because they serve two entirely different functions. Section 1157's refugee program is entirely elective. The president chooses whether to admit refugees. It's not something that refugees in other countries can apply for. It's decided between the countries. There are a host of benefits you get if you are admitted through that program, but 1157 is not the provision that implements the Article 33 obligations. That happens through the asylum processing that's under 1225 and 1158. And that asylum processing is also how you determine whether someone is entitled to withholding.
Mr. Suri gave some responses to Justice Kagan in saying that there's a subset of people who are arriving in the U.S. who are, as opposed to longstanding people. The problem with that is those people who are arriving, he says, are present in the U.S. So I'm not sure how his answer gets you around the surplus problem.
Yes, I agree. My friend made a number of new arguments about surplusage that weren't in the briefing, and I think that is one of them. But I would note exactly what you said. Making it a subsection doesn't mean that it's not redundant. It's still entirely redundant.
Well, that's true, Ms. Corcoran, that it's a subset, and so there's still redundancy. But I suppose if Congress in IIRA had just created this big deal about expedited removal and said that expedited removal was what arriving people got, it might be that they just wanted to emphasize that just because you were that you were subject to the expedited removal procedures did not mean that you still couldn't apply for asylum. So the fear, if you might say, is that if they had just had that one physically present provision and struck out what had previously been in the statute, the arrive at the port provision, somebody might have thought, like, all these people that are now being subject to expedited removal do not have the right to apply for asylum. And this provision is supposed to make clear that they do.
There's no reason for the inspection mandate to need to make that clear because 1225B, the asylum processing section, it's in B12A, has a whole process in place for how you assess asylum claims by arriving aliens. So that credible fear interview provision says if an immigration officer determines that an alien who is arriving in the United States has expressed a fear of future persecution, then the immigration officer shall refer them for a credible fear interview. And then there are a host of provisions that explain how that credible fear assessment plays into expedited removal. So there would be no way that someone could read the entirety of 1225 and be concerned about how it applied to arriving asylum seekers.
Can I ask you a question? I feel like there's some slippage between arriving and arrives, and as the Chief Justice pointed out, the language is arrives in. I mean, arriving sounds more in the process of. Arrives in sounds more like you've reached your destination. How do you know, under your theory, when the person is close enough that we could say they have arrives in or arrived in the destination? I mean, what if there's a queue and they're far back, or what if they arrive not at a port of entry? How close do you have to be to the border? Could you say that someone arrives in the United States if they're at a portion of the border that does not have a port of entry? Like, what is it? If it's not crossing the physical border, what is the magic thing or the dispositive thing that we're looking for where we say, now that person we can say arrives in the United States?
So I'm going to try and keep that in order in my head, and I'm going to start with the first point, which is actually it's the arrives in is the tense that triggers the inspection under 12258. But is arriving in is the language that triggers the credible fear. That's the provision under 1225B that mandates asylum processing within the context of expedited removal. As the government acknowledges, and I think Your Honor just said, is arriving in does suggest a process. And in fact, that's exactly that determination is what's happening under the turn-back practices. So they have immigration officers standing at the border asking arriving non-citizens, what's the basis for your admission? They get right up to the borderline. And if they say, I'm here seeking asylum, then the border officer turns them away when, in fact, 1225B says that if the immigration officer determines that the person is seeking asylum, he shall refer that person to a credible fear interview. So that argument stands separate from the inspection mandate. And what used to happen is that you'd have inspection, and that's how you'd find out someone had a fear, and then that would trigger the credible fear interview. But both of those provisions are at play here.
Okay, can you answer the question about what is the dispositive thing that has to happen to say that someone arrives in?
Yes, so a person arrives in the United States at a port of entry when they are at the threshold of the port's entrance about to step over. So they are arriving there. I think that's consistent with ordinary meaning. I arrive at my house or I arrive in my yard when I'm going through the gate. Now that process of arriving is interrupted by the border officer physically blocking them from completing the arrival such that the person never arrived. But the process of arriving is beginning at that moment.
And is that just for the person? I mean, if there's a line, and you're far back and you hear, oh, no, we can't cross the border today, have they arrived in and been turned away, or is it only the person initially told? And how could it be something different if you arrive at a port of entry versus if you cross the border or you arrive on the other side of the border, the Mexican side of the border, but say cross into Texas or try to cross into Texas where there's not a port of entry?
Yeah, so to start with the hypothetical where you have a line growing, I think that our position is not that arrives in the United States is doing no work at all. The question is what arrives in the United States at a port of entry means. And I think that means you have to be at the threshold. If I'm in a line waiting to get into my house for some reason, into my yard, and I'm half a block back, I haven't actually started the process of arriving in because I'm in a line waiting to get there. So I think, if the word was being passed down a line that's going over the bridge and people are turning away without actually getting to the threshold, they wouldn't fall under the statutory inspection mandate or processing mandate. The second question, I think, has to do with how arrival looks between ports. As a practical matter, the borderline isn't generally delineated in a way between ports that would allow for this kind of discernment about have you reached the threshold of the port.
But doesn't the statute say whether or not at a port of entry?
Yes. So I was going to get to that part next. So we take out at the port of entry when we're talking between ports, and the question is what does it mean to arrive in the United States? I think you would have to be at a place where you could, in fact, cross. So if you got up to, let's assume it's a place on the border where there is an actual line, identifiable line, I would say the same analysis applies, right? Have you made it to the threshold and you're about to step over?
So anybody at the water's edge of the Rio Grande on the Mexican side has arrived in?
No, the border is halfway through the water.
All right, so they've got one step short of halfway through. They've arrived, but somebody who's on the water's edge has not arrived.
Yeah, I think that's right. So you're looking at being at the threshold of when you're going to cross.
And so somebody who's at the fence has arrived in, but somebody a step away from the fence has not arrived in?
Well, so the fence, if we're talking about the border wall, that is, the border wall is entirely on the interior. So, in fact, anyone who gets to the border wall is also physically present.
So anybody who's arrived at the fence is in?
Yes, but that's just a matter of geography that they're already present.
Okay.
To take the hypothetical, though, what if there was a
fence
border
wall
on the borderline? There, the analogy that I think of is a stadium. So I'm arriving at a stadium when I'm at the entrance going through the turnstile. I probably wouldn't describe myself as arriving in the stadium if I'm still on the perimeter making my way to a place where I can enter. So I don't think someone who's
out of top of the wall they're in, but if they're at the bottom of the wall they're out.
Oh, so now they've climbed.
Yeah. No, I'm just trying to understand what it means.
Yeah, so I suppose
we're going to get these, we're going to get as soon as we decide what it means, we're going to get cases.
Well, so as a practical matter, that's not going to be a concern because the wall is in fact within the perimeter. A hypothetical wall that was on the line and a person had kind of gotten to the top and was about to fall over, I guess, would potentially be arriving.
How come somebody who's in the line isn't in? I mean, if the whole point is to make sure that people who are attempting to get into the country have the opportunity to file asylum claims, and they've made it all the way. Why does it matter he's second in line?
I think that's just a function of arriving in.
So the whole debate boils down to the one person who's at the port, the one person who's at the front of the line.
Yeah, and I think that's because I think it's important.
So the rest of the case, you agree with the government on?
No,
everybody else in the line, everybody else who's being metered, doesn't have an asylum claim. Just the person who's.
They have an asylum claim. They have to get up to the border to present it. Now, I think maybe the question is if the government was stopping people from getting physically to the line, because if you're waiting in line and you just decide to abandon waiting and you don't actually make it to the threshold.
No. These people want to make these claims. They're there.
Right.
And they're being metered and they're told, no, not today. And you're saying the person who's made it up to the inspection officer gets to make that claim, and everybody else who's been waiting there maybe for hours or days doesn't.
Well, they just then, once they get up there, can make the claim.
But they have to get up there, yeah.
Yeah, but there's no reason to think they wouldn't be able to do that. And I think it's important to remember that from 1917 to 2016, 99 years, there was not a single example of a turnback. So what was happening is people would come through the port. At that point, when they were in the port, they would be inspected and processing would happen. So it's an unusual scenario we have here where we have the officer standing there and turning people back.
And now we have these expedited removal processes at the border.
Yes.
So many of them are not getting in at all, but they're coming to the line and they're at least being questioned and permitted to make the claim.
Under the expedited, if they were being applied the way they're supposed to.
I think your point that you're making is the statute is very clear that anyone in the U.S. Now, the other side says a foot. I don't know why the foot is magical. I could put my hand through or my nose through. I don't know. Why does a foot count as opposed to a piece of your body count? So if you're up on the top of this wall that's not on the U.S. side. But my point is, in asking or clarifying this question, is arriving at the border means you're knocking on the door, correct?
Yes, that is what it has meant for 99 years before this.
Mr. Surya suggested that's not what it meant, that that's not what the federal regulations said, that that's not what practice was. Was he simply wrong about that? In reading the papers, I understood that up until 2016, anyone who knocked on the door had the opportunity to make the claim, and they weren't guaranteed success, but they could make the claim.
That's right. So the government purports to cite a few earlier cases, which it says support its position. That's Lang Mei Ma, Hong Kai Chu, Meze, the Ellis Island case. All of the cases that the government is citing, its sites are playing fast and loose with entry. So each one of those non-citizens was present in the United States, arrives in the United States, at which point they were subject to exclusion proceedings. That's the statutory process that you got if you arrived and then you weren't actually admitted or physically present in the country. That is all that we're just looking for, the statutory process to be applied to our class members, or we were when this policy was in effect.
I just want to make sure I understand exactly. There's a line of 50 people trying to get in. The first one knocks on the door. So maybe he or she is processed. I don't know how many people are there processing, but if there's one person there, maybe person 3 to 50, they don't have a claim, right?
Yes.
No, wait. Yes or no? Do they have a claim or not?
They are going to have it's going to depend on whether it's a reasonable delay.
Well, what do you think a reasonable delay is?
So that's under 7061. I think Justice Sotomayor made the point earlier that the Ninth Circuit made a determination that this was complete withholding because there was no ability to wait. There was no ability to put your name on any sort of meaningful list that would ensure that you were going to.
So it's not knocking on the door; it's getting your name on a list.
So it's a turnstile if you're at a land port and there's a plaque halfway across the bridge, so not a physical door. But yes, so when you go through the line, if it's working the way it should, you should make your way up to the borderline, at which point you come across and you are processed.
Maybe I just don't understand. I mean, it depends kind of on how long the line is, right?
Yes. There are non-examples prior to the turnback policy, and even during the turnback policy, of there being kind of lines of people waiting to be process who are outside of the United States because under the prior practice you came through the turnstile and then you were inspected and processed. Now there could have been long waits within the port. That certainly happened. And that would have been subject to kind of a reasonable delay analysis. But this idea of kind of lines and people piling up on the Mexican side of the border didn't happen until the turn-back policy was put in place, and you got this bottleneck of people waiting on that side.
No, I understand that, but I'm still struggling with the Chief's question. And we do have situations where there are lines. And I had thought you'd said to me and Justice Sotomayor or others that the first person at the turnstile with the inspection officer has arrived, but people further back in the line haven't. And now I thought I heard a different answer to the Chief Justice, and I'm just wondering, I really do, whatever you think it is, I want to know what it is.
I think I was skipping ahead when I answered the Chief's question to kind of the nature of the 7061 claim and the difference between withholding.
I'm just curious what arrives in means.
Arrives in means you reach their threshold. I didn't mean to create confusion about that when I was answering.
Okay, so it's the person at the turnstile, it's the person halfway through the Rio Grande, not somebody two people back, not one person back, not one person who can't reach across the halfway point of the Rio Grande, none of them.
Yet you have to reach the threshold in order to be subject to the 1225 mandates for inspection.
So how does that fit, Ms. Corcoran, with 1225B1A which says if an immigration officer determines that an alien who's arriving in the United States is inadmissible, the officer shall order the alien removed from the United States. Now, to me, that suggests not you remove somebody from the United States when they already have crossed the threshold, not when they are knocking at the door. So that suggests to me that arriving in suggests that they've already crossed.
So it's a process of arrival. So the person is arriving in when they're about to step over the threshold. And again, I would go to the plain meaning and I think about kind of being at a house or a yard. If my husband called and said, "Are you arriving at the house?" as I'm walking through the door, and I said no, that would be a strange answer to give him. The ordinary meaning is yes, I'm.
Well, but if it's arriving in, the officer shall order the alien removed from the United States. That seems to suggest that your view of plain meaning, whether it is plain or not, is not the statutory meaning, because if you're removing somebody from the United States, that person has clearly made it over to the United States. You don't remove somebody from the United States when they're just knocking at the door.
Well, so I think that provision makes sense if you remember that removal is a legal term. It refers to removal proceedings. So what that provision is assuming is the completion of arriving. And because in 1996, when Congress was drafting the language, it had no reason to think that 20 years later the government was going to change its position and start blocking people while they were in the process of arrival. So you see in the regulations, and I think also in SAIL, kind of the understanding that the process of arrival starts when the person is at the threshold and it continues as they step over the threshold and are being inspected. So I don't think there's an inconsistency there.
And so to clarify, when the person is arriving at the threshold, the process of inspection, you say, kicks in based on their arrival. And that process could take place on U.S. soil, presumably without metering. The inspectors are on the U.S. side, and so they're asking and they're investigating, and the person is in the U.S. at that point. But the obligation to do that kind of inspection, I think you're saying, kicks in based on the person's arrival.
Yes, that's exactly right. And it makes sense when you remember that that is how it had worked from 1917 to 1996 when Congress was amending the provisions in IRS.
Can you speak a little?
It'll be interesting to read the actual transcript of the oral argument, because I believe that both you and Justice Sotomayor and Justice Jackson on several occasions have used the phrase arriving at. I think you said you arrived at your house, but that's not the term that is in the statute. Do you think there is no difference between arriving at a location and arriving in the location?
Yes, thank you for the opportunity to clarify. So we have in the United States at a port of entry. I can explain the amendment history on how we ended up with the prepositional phrases in that order. But I think that my first order answer is in is just how you describe being in a region. You wouldn't say at the United States. You would say in the United States. I am arriving in Baltimore when I'm on the train as it's coming in. I am at Penn Station when I'm in New York. So that's the difference in prepositional phrases, which even if it doesn't completely answer the question, does give you some pause to say, well, maybe in isn't doing the work that the government is suggesting here because it has to do with kind of the natural way that we talk. But the way we ended up with that order of the prepositional phrases is that
Well, I'm not quite sure I understand that. So there's been talk about knocking at the door. Do you think someone who comes to the front door of a house and knocks at the door has arrived in the house? The person may have arrived at the house.
No, but that's past tense. Are they arriving in the house?
Does a person arrive in the house when the person is not in the house and is knocking at the door, asking to be admitted to the house?
Yes, I think here the door is open. The officer is standing on the other side of the threshold. The person gets there and is ready to take the step over, right? The officers and the asylum seekers here were toe-to-toe. This was happening right at the line, and they're about to step over. They are arriving present tense. Once they're inside, they've arrived past tense, but we know that Congress used the present tense here.
Well, it does make, I gather you think it makes a difference. Whether there's a door or a turnstile, you have to be there. If you're at the end of a long line, you're not there. You haven't arrived at the turnstile.
Yes.
Okay, so then does it matter how many people are processing the arrivals? I mean, how quickly the line's going to move? I mean, it strikes me as a very significant factual question. In other words, it's not, if you're at the end of the line, you're not covered by the requirement to process. Is that right?
Yes. So once you get to you have to arrive, and that's just the nature of the language that Congress used. However, if the government was complying with the inspection and processing mandate, people would be going right through the turnstile. There is no stopping or processing that happens at the turnstile under the prior practice. A person goes through, and at that point, they're—
So you don't even have to knock?
No, there was no knocking. You went through. There was no immigration officer who was stopping you. You're going straight through the open door. You are now in the inspection area. You're in the port. And at that point, there would be perhaps a delay of processing for the reason you say. That delay would be subject to 7061, unreasonable delay. Here we had a complete withholding. But I think maybe where we're getting stuck is kind of the idea that processing is happening at the border. That only happens under the turn-back policy. That's the only situation in which you're going to have immigration officers interacting with asylum seekers on the other side of the border.
So historically, if you were at the end of the line, you still went through.
There was no line. People just—
Right, there was no line.
Yes,
this only became an issue, is what you're saying. And so the arrives in wouldn't have had the significance in 1996 is what based on the historical practice, and now we're trying to figure out what it means when there's a new practice not envisioned by Congress.
Yes, that's right. And if I could go back to something you said earlier, which is the logic or the logical problem the government has with treating this kind of the change in language as if it suddenly substantially narrowed access to asylum at the ports. Not only is that illogical, but it defies the express purpose that the text was seeking to achieve, to quote Justice Scalia. We know that the reason that Congress amended 1225A1 was to expand the category of applicants to include people who were already present in the United States and people who entered between ports because it needed to put them on equal footing. So to read that language as then re-disadvantaging people who attempt to enter lawfully makes no sense at all.
Can I ask you, this is a new practice. Justice Kavanaugh just said a new practice not envisioned by Congress. The Chief Justice says we have a significant factual question here about how this actually works. Why wouldn't we wait until we had an actual policy with real facts in the record regarding what's going on? I mean, even if this is not technically non-justiciable, even if there is jurisdiction in the literal sense, we do have some control over whether or not we reach and discuss issues. And it just seems to me that we have a lot of hypotheticals regarding how this policy may have worked in the past, how it's possibly going to work in the future, but we don't have a policy in effect right now that we can actually rule upon. So how should we take that into account as we think about this?
Yes, thank you, Your Honor. So as we explained in pages 15, I think to 21 of our brief in opposition, this case has virtually no ongoing significance, certainly not for the plaintiffs. Now, the government has sought this court's review because it wants to preserve its degrees of freedom in the future. Right now, the border is closed under other authorities, but maybe if that's not true in the future and conditions change. That is not a reason for this court to grant plenary review. The government suggested—
I mean, if the government were to just bring its own action, I think Mr. Suri has conceded that they wouldn't have standing because they don't have an actual plan in place that they're trying to implement.
Yeah.
What they're doing is saying we have this, essentially extant district court order out there, and at some point in the future, we might want to have a policy like this. So Supreme Court, tell us now whether or not that's going to be unlawful.
Yes, that's what they're seeking. That doesn't, in order, as the court said in Camreta v. Green, both parties have to have a live interest in the case in order for the court to proceed. And that explanation doesn't go to how plaintiffs continue to have an interest in a declaratory judgment against a policy that was rescinded 5 years ago. And so I think it's odd to raise the voluntary cessation exception here, where it's the defendants who want to continue
Absolutely.
to do the policy.
Usually voluntary secession is the defendant wanting to avoid the court's orders. And then they remove the policy so that the court doesn't order. Here we have them pointing to the voluntary secession as a reason for the court to weigh in on this policy.
Right, and it's the government that's saying, the government has control over the extent to which it's likely.
Counsel, do you think the Ninth Circuit was wrong to say that it was not moot then? You didn't challenge that in your brief.
No, so what the Ninth Circuit said that the declaratory judgment was moot and the dissenting judge agreed. The reason that the Ninth Circuit reached its holding was because of the transit rule injunction, that smaller class, which at that point, that injunction was still in place and it imposed a number of obligations on the parties. So the Ninth Circuit was not wrong about that. But on remand, the parties agreed to essentially dissolve the injunction because the burdens that it was placing on the parties no longer had any benefit to the class members. The class members had been identified.
So you're taking the position it's formally moot?
I do think it's moot for the reasons—
Why didn't you make that point in your brief?
We wrote 6 pages of all the reasons.
In the bio?
We thought, yes, in the brief in opposition. It wasn't until the reply in support of cert that the government suggested Munsingware vacator. I'll say we don't object to that. We didn't address it in our brief in opposition because that would be an odd thing for a respondent to suggest. And once the court granted review, we focused on the merits. But to Justice Jackson's point about Munsingware vacator, we don't have an objection, and I think that resolves all of the government's concerns in this case.
Thank you, counsel. Justice Thomas? Justice Alito? Anything further?
On that last point, the court said a declaratory judgment. It was vacating that. And it's also vacated the preliminary injunction?
No, so the declaratory judgment is still in place, but I think is moot for the reasons that the Ninth Circuit said. The Ninth Circuit went on to reach kind of the statutory interpretation question, not with respect to the declaratory judgment, but with respect to the transit rule injunction, which would only be in place if the underlying statutory question was resolved in the plaintiff's favor. But then that injunction was dissolved. So we really have nothing that's before the court at this point.
Thank you.
Justice Kagan?
Is your position that when a person gets to the border, she has a right to apply for asylum only, or that she also has a right to enter?
So enter so a right to cross, I'll say cross.
A right to
avoid,
cross.
The entry infection. So I think the right to cross is tied up in the inspection and processing mandates that are on the government. So we have a 706(1) claim here. It's based on ministerial duties that attach to the government under these circumstances.
And if the United States figured out a way to do its various things that it has to do without having the person cross, would that be sufficient? You could have a Zoom interview or something like that.
Yeah, I suppose that 1225 assumes that all of this is happening on U.S. soil, and I think for good reason, because that's how it already worked. The government's extraterritoriality concerns might weigh against doing some sort of process, but I don't know that I have a stake in pushing back on that way of approaching things.
Okay.
Justice Gorsuch, anything further?
Just briefly. You mentioned the Court of Appeals revised opinion. It said it didn't think the case was moot because of the equitable relief still present, which I took to mean both the declaratory judgment and the injunction. Am I mistaken?
So yes, they were both left in place. The reason that the Ninth Circuit reached the underlying statutory interpretation question was
because they were both in place. Yeah. Okay. Thank you.
Justice Kavanaugh?
On that question that you made a point on about why Congress would give better treatment to those unlawfully in the country, I guess one response to that, I just want to get your reaction, would be we should just interpret the rule in front of us or the statute in front of us by its terms and not try to figure out all the things that might be going on with people unlawfully in the country to try to make it all fit in some perfect world. Rather, we should, there are lots of issues with people who are unlawfully in the country but the only issue before us is trying to figure out what arrives in means and not worry about that. I just want to get your reaction to that.
Sorry, I'm not sure I followed the question.
You were saying that if we interpreted it the government's way,
yes,
that Congress would have been privileging people unlawfully in the country. And my response or my question to you is, whatever's going on with people unlawfully in the country, the sole issue before us is trying to figure out what arrives in means when you're at the border, and whatever the effects of that are in terms of creating disparities, we can't sort all that out here. All we have to do is focus on the issue before us. So what's your reaction?
Yes, thank you. Sorry, it took me a little bit to get there. So I think it's less about advantaging people who are already in than it is about addressing the disparity incentives that Congress was trying to resolve in 1225. So under the government's framework, if you are an asylum seeker coming to the United States, you should not go to a port because you will be turned away. You need to cross the Rio Grande, you need to come in between ports. That is the exact opposite of what Congress was trying to accomplish there. And I know also— But
the answer to that could be better enforcement of people coming in unlawfully, and Congress might have assumed, particularly in 1996, when there was an increased effort to prevent illegal immigration, that people wouldn't be flooding in unlawfully. That turned out not to be accurate, but that might have been the expectation in 1996. So,
but I don't think that then explains what Congress was doing in 1225. It creates this applicant for admission category in order to unify the proceedings, the deportation and exclusion proceedings. What the government is suggesting just makes all of that somewhat nonsensical.
Okay, completely different question. Last one. This seems very artificial, trying to figure out at the threshold, on the line, in the middle of the river, because wherever the line is, the government's presumably going to stop you on the other side of that line and prevent you from getting to wherever the line is, right?
So that you're getting across the line.
Yeah, so if we define it as the threshold, the government's going to stop you short of the threshold, or try to.
I understand.
And if we say 100 yards from the threshold, they're going to stop you 125 yards from the threshold. In other words, the point, I guess the arrives in thing seems kind of artificial. The whole question, the bigger question, it seems to me, is can the government physically stop people before they get to whatever that line is, no matter how we define it? And that seems like not a statutory question, more of an arbitrary and capricious question, but maybe I'm wrong. Just want to get your reactions to that. This whole idea, if you're second in line, or for the government, wherever we define it, is going to stop you when they want to implement this policy on the other side of that line. You follow that?
I do. And so I think that maybe the factual premise that's inaccurate there, the port goes right to the borderline. So the government understands ports as being kind of that geographic space. So the threshold of the port is the borderline. So you can't really, if you moved the threshold further in, then you have people who are present in the United States. If you move the threshold further out, well, now we're in Mexican territory and the government doesn't have authority to act there.
Well, that's okay. So that's a good answer. Does the government, how far into Mexico, maybe the SG, will the government go? Maybe they don't want to answer that. to stop people.
Yes. I think if the government starts going well into Mexico,
well into, is that 100 yards? 150 yards? That's not the threshold anymore. And will they go into, again, you might not have the answer to this question, but the whole thing seems kind of artificial to me, because the government is going, if they want to do this policy, they're going to stop you on the other side of the line.
Yes, and I would say there that so if we start to have the government kind of circumventing further into Mexico, whether it's 10 feet or 100 feet, we move out of the inspection and asylum processing mandates in 1225, and now I think it's a question of just kind of ultra vires acting without authority in another country.
All right. Thank you for your help.
Justice Jackson?
We don't have the answers to Justice Kavanaugh's good questions because there is no policy in effect, right? We don't know.
That is right. I was going to make that point as well. Right now we have a legal question that's unanchored from any actual practice before the court.
Thank you.
Thank you, counsel. Rebuttal, Mr. Suri?
Just a few quick points, Mr. Chief Justice. First, this court should decide this case. The case is not moot because there is still effectual relief that the court could award, namely lifting the class-wide declaration and the individual injunction to which the government is still subject. There's also a strong practical reason for the court to decide this case. Administrations of both parties since 2016 have consistently said that this is an important tool in the government's toolbox for dealing with border surges when they occur. I can't predict when the next border surge occurs, but I can say that when it does occur, this is a tool that DHS would want in its toolbox. It's not something the court should leave to future uncertainty. We've been faulted here for not having a specific policy in place, but that's not really fair to us. There's a class-wide declaratory judgment saying that this practice is unlawful, and I think the government should not be faulted for conforming its current conduct to what a court has declared to be the law. Once that declaratory judgment is lifted, we'll take appropriate steps at that time. Second, the text of the statute should control the court's decision, and that text is arrives in the United States. We've heard attempts to substitute other language that might be more ambiguous or more susceptible to respondents' interpretation than the language Congress actually used. For example, we've heard many references to arriving in the United States, but the specific language at issue here is arrives, not arriving. Further, as Justice Kagan correctly pointed out, there's a separate provision of Section 1225 that says that arriving aliens can be removed from the United States in certain circumstances. And that suggests that even the arriving category is limited to aliens who've already crossed the border. Even if you think that there is some ambiguity in the term arriving, though, the correct approach is to use the clarity of arrives to resolve the ambiguity in arriving. You shouldn't use the ambiguity potentially in arriving as an excuse to ignore the clear word arrives. Similarly, we've heard attempts to replace arrives in the United States with arrives at a land border or arrives at the threshold or knocks on the door. None of those terms are the terms Congress actually used in the statute. Moreover, even when a previous version of the statute said arrives at a land border, this court still interpreted that to refer to aliens in the United States. We've relatedly heard a suggestion that the alien arrives at the port of entry because the port goes right up to the border. We don't think that's accurate. The entrance to the port might be something like a quarter mile from the border. So even if you think the question is whether the person arrives at the port, the person hasn't arrived at the port. More importantly, the real question is whether the person arrives in the United States. Finally, respondents' position raises serious line drawing problems. It's not clear from their position whether you have to be at the front of the line, the back of the line, or the middle of the line. It's not clear whether they're distinguishing between someone who is stopped by a border officer versus someone who is stopped by the Rio Grande versus someone who is stopped by the border wall versus someone who is stopped by Mexican authorities working in concert with the United States, which is something that could happen in response to Justice Kavanaugh's question. I don't think we'd ourselves go into Mexico, but we could cooperate with Mexican authorities to stop people from reaching the border of the United States. Our position avoids all of those line drawing problems because Congress drew a clear line here. It said that if you're outside the United States, you can apply for refugee admission under Section 1157. If you're in the United States, Whether you've been here for a long time or you've just arrived, you can apply for asylum. The court should respect the line that Congress drew.
Thank you, counsel. Case is submitted.